Illinois child support laws after age 18. Child support is money to help support the care and raising of a child. In Illinois, when does a child stop being a child and therefore stop needing support? What is a parent's duty to a child as the child continues to age? What are the Illinois child support laws after age 18? The Illinois statute defines a child for the purposes of child support. He term, child, shall include any child under age 18 and any child age 19 or younger who is still attending high school. 750 ILCS 5/500 A. Child support continues in Illinois until the child turns 18 and, if the child is still in high school, until the child graduates from high school or turns 19, whichever comes first. Every child support order in Illinois even requires that the child support termination date be included in that child support order. Without a termination date on some order, child support continues until a motion to modify support is filed. Is child support ever extended beyond age 18 or 19 in Illinois? Yes. If your child is significantly disabled, you will have an obligation until that child overcomes their disability. Personally, most courts in Illinois will look at an adult disabled child's needs and then compare those needs to the child's Social Security disability allotment. If the child's needs are being met by the allotment, then there will be no ongoing child support obligation. An additional obligation arises when children leave high school, college, and university. Parents of college students in Illinois have an obligation to contribute to their children's university education, and the amount is almost always higher than child support was. Do I owe child support if the child becomes emancipated? Sometimes a child can become an adult even before they are 18. This was common in the old days when 16-year-olds would get married or join the army. Emancipation hardly ever happens anymore. In order to terminate child support because of an emancipated child, there has to be an actual petition for emancipation filed in the Illinois courts. If the child does manage to become emancipated, an ongoing child support obligation in Illinois definitely ceases. What happens to child support owed after the child turns 18 in Illinois? The Illinois statute says you still have to pay the same amount of support until your arrearage is satisfied. The statute even says if you were paying extra before to pay off your arrearage, you still have to pay that extra amount after the child is an adult. Can you modify a child support arrearage payment after the child turns 18? The Illinois statute doesn't say you can modify your child support arrearage payment. The statute doesn't say you can't modify your arrearage payment either. In lieu of modifying an arrearage payment, just don't pay or pay what you can. You will still owe the arrearage. Don't forget that interest is accruing on that debt at a 9% annual rate. This rate will change to 5% in 2021 per current Illinois legislation. Enforcement of child support in Illinois after the child turns 18 in Illinois. If you don't pay child support, you can have your license suspended, your passport denied, and you may even be sent to jail. These powers of enforcement do not expire simply because the child turns 18. How to really handle child support owed after a child turns 18. An arrearage of child support is an obligation between two people, the parent who owes child support and the parent who is owed child support. The parent who owes money should come up with some amount of money immediately to satisfy the arrearage and end the financial relationship between the two parents forever. What that amount is up to the two parties. The arrangement you come to with the other parent must be put in writing and entered as an order with the court. The court must approve of your agreement. If the child is no longer a child, then the court doesn't need to consider the child's best interests. The court will always approve any agreement the parents have as to arrearage judgments. What if I can't come to an agreement with the other parent as to the child support arrearage? If you cannot arrange an agreement as described before, do the following. If you are the parent who is owed money, get an order memorializing exactly what the obliger parent owes you. Then the parent owed the money can take the judgment for the arrearage amount to a collections lawyer who will register the judgment in the civil division of the county courthouse and begin garnishing the obliger parent's wages at 25% of disposable income and seizing the obliger parent's assets. If you'd like to talk more about what happens to your child support obligation after your child becomes an adult, contact the law office of Russell D. Knight today. Call us at 773-334-6311 to talk with an experienced Chicago divorce lawyer.